Hi, good morning, folks, and welcome to Learn to Real Estate. And my name is Scott Buida, and we're going to be continuing with our flashcards on contracts. And our first card is, what is meeting of the minds? Very interesting keyword here. Meeting of the minds. Okay, meeting of the minds is an agreement to the exact terms of a contract by all parties involved. It occurs upon acceptance of an offer, including its terms and conditions. Meeting of the minds. What is an express contract? Is our next card here. What is an express contract? Okay, an express contract is a written agreement that includes the elements needed for a valid contract and specific terms of the contract. Okay, it is contrasted with an implied, unwritten contract. For example, an agreement of sale that is in writing is signed by the buyer and seller, describes the property, states the price agreed upon, and specifies the terms of payment, is an express contract. Express meaning to the point, short, simple, and sweet. Think about that. An express contract. Is any special reprinted form required for a valid real estate contract? Is any special pre-printed form required for a valid real estate contract? No. Any form that contains the necessary elements of a real estate contract will do. I'll repeat that. Any form that contains the necessary elements of a real estate contract will do. A contract does not have to be typed. It can be handwritten. Some states, however, require real estate licensees to use either a specific pre-printed form or the services of an attorney. The advantages of a pre-printed form is that it reduces the risk that some elements of the contract may be omitted or misinterpreted. Makes sense. What is acceptance? And we're talking about acceptable. Acceptance is the act of agreeing to accept an offer. Acceptance is an offer creates a contract. Acceptance of an offer creates a contract. However, any changes to the offer constitute rejection of the contract and substitution of a different contract, known as a counteroffer. This is a new offer to the other party. I'll repeat this. Acceptance is the act of agreeing to accept an offer. Acceptance of an offer creates a contract. However, any changes to the offer constitutes rejection of the contract and substitution of a different contract known as a counteroffer. This is a new offer to the other party. Interesting. Can an offer or counteroffer be rescinded? That is, withdrawn. It's good maybe to stop the tape and to think about the answer for yourself to see how you can take in the new knowledge if you don't know it. But an offer or counteroffer can be withdrawn at any time. before it's accepted. Once it's accepted, it is binding. Okay, an offer or counteroffer can be withdrawn anytime before it's accepted. Once it's accepted, it is binding, or it becomes a binding contract. Okay. What is the meaning of rescind? As you can see, all these go together. To rescind is to withdraw. For example, Abel offers to buy a certain house from Baker. Before Baker accepts the offer, Abel rescinds it and therefore is not obligated to follow through on the purchase. Okay? To rescind is to withdraw. All right, next one here. What is a bid? What is an offering price? An offering price, a purchase to offer. They're all the same thing. A bid is the amount someone's willing to pay. For something that is offered for sale. In the case of real estate, this is the same thing as an offering price or a purchase offer. Those two are the same. What is an asking price? What is negotiation? The asking price is the list price that an owner would like to receive. Negotiation is the process of bargaining that precedes an agreement. Though negotiation, the prospective buyer often causes the seller to accept a sale price lower than the asking or listing price. Okay? And our next card here is what is meant by voidable. Void. Okay? Voidable means capable of being voided, declared void, but not void unless action is taken to void it. A voidable contract is one that can be voided by one or both parties. Remember, there's a difference between a void contract and a voidable. Okay. Often, only one party has the right to void it, while the other party is bound by its terms. An example is a real estate contract entered in by a minor is voidable, only by a minor. If a landlord leases an apartment to a minor, the minor may honor the lease and rent the apartment, in which case the landlord is bound by the lease. If a minor decides not to rent the apartment, however, he or she may void the lease without liability for performance. The lease is a voidable contract. Voidable is only by the minor. What is meant by void? Okay. Void means having no legal force or binding effect. To void something is to render it void. For example, suppose a listing contract stipulated that the property could be sold only to a person of a certain race. Since the stipulation is contrary to anti-discrimination laws, that particular clause is void and therefore unenforceable. Okay. Is buying real estate just like buying goods in a retail store? buying real estate just like buying goods in a retail store. Things in retail store are personal property, where real estate is real property, not personal property. No, in retail store, all or most goods have a price set by the merchant. Although the customers can sometimes negotiate a lower price, in most cases the price is fixed, and the customer can take it or leave it. In real estate, the asking price set by the seller is often just a starting point, and the seller expects a negotiation process to begin. What is a bill of sale? A bill of sale is a written instrument given to pass title of personal property from a seller to a buyer. It often accompanies real estate transactions where furniture and portable appliances are often sold along with the real estate. Okay, a little picture of a bill of sale. All right, folks, we have one more here to wrap it up, and that'll give us our 10-minute chunk. How is personal property sold? How is personal property sold? Well, we just went over something that told us the answer. And here is the answer. A contract for the sale of personal property needs not be in writing. It may be oral. In the old days, it was a handshake. When it is in writing, the agreement is called a bill of sale. Okay? Hey, thanks, guys, and hope this video helped you. And give it a thumbs up if you like, and take a break, and come back, and we'll have another one for you, and continue our learning process. Thank you so much.